one is legislative codes. Legislative codes contain laws from the legislatures, the legislative branch of the government. These laws are often referred to as statutes. Statutes are organized by subject into code volumes, along with other legislative laws that are still in force in that jurisdiction. Code sets have indexes that can be used to find code sections by topic. Code sets are generally the only source you need to check for legislative laws. Code sets also include court rule volumes that describe court procedures. The code sets can be searched by topic, popular name, and table of contents. There is also a table that tells where a particular session law is found in the code. Legislative history materials are materials that provide information about why the legislature made a certain law. Another example is cases, which is also another primary source of law. Cases are the laws that come from the courts, the judicial branch of the government. They are referred to as common law as distinguished from the legislative law. Cases are court decisions or opinions. They are usually decided by the appellate courts. Under the doctrine of state decisions, which we call normally as precedents, these decisions are precedents that are generally to be followed in future disputes. They come out chronologically in reporter volumes. Then we talk of digests, which contain descriptive word indexes and tables of the contents that help us identify appropriate topics and key numbers that will lead to cases on our topic. It is also possible to identify appropriate topics and key numbers by looking at the headnotes for cases we have found through secondary sources. Cases can be located by name using a table of cases. Now let us come to secondary sources of law. These are legal dictionaries. Legal dictionaries give definition of words related to law. The words are arranged alphabetically. Then there comes legal encyclopedias. The legal encyclopedias are multi-volume sets that provide information on many topics of law. The topics are arranged alphabetically. Then there comes legal periodicals. Legal periodicals provide articles on a wide variety of law topics. Annotations. An annotation is a collection of case summaries on a certain topic. Then there are treatises. Treatises are a rich source of legal information on a wide variety of topics. They are often written by highly respected authors. They can be located by author, subject, title, keyword, etc. using a library catalog. Then friends, there is another secondary source of law which you call as case law. The brief definition of case law is that case law is a part of common law. It consists of judgments given by higher appellate courts in interpreting the statutes or the provisions of a constitution applicable in the cases brought before them. These are called precedents. They are binding on all courts within the same jurisdiction to be followed as the law in the similar cases. All the time, these precedents are recognized, affirmed, and enforced by the subsequent court decisions. Case law is a dynamic and constantly developing body of law. Case law contains the facts of the controversy as well as the holding and reasons as to how a particular decision was arrived at. It may even contain concurring as well as the dissenting opinions of the judges. Case law derives from the application of law to facts of individual cases. Indeed, it is a collection of reported cases that form a body of law within a given jurisdiction. Case law refers to the precedent and authority set by the previous court rulings or judicial decisions and administrative legal findings or rulings. This is one of the main categories of law with constitutional law, statutory law, and regulatory law. Although statutory laws created by the legislative bodies in concurrence with the constitutional law strive to provide overall direction, guidance, and rules for society at large, It is impossible to deal with all the situations, legal issues and the questions by this manner alone. Our judicial bodies are tasked with interpreting the law and in doing so often set precedent where statutory, regulatory and even constitutional law is vague, unclear or silent. All of these precedents make up case law. Case law is a primary source of law, and being able to identify, read and understand case law is integral to successful legal research. It is the law developed over the time by judges in superior courts. Each case or judgment delivered by these superior courts is the solution to the dispute between parties to the case. Once the judgment is delivered, it becomes precedent that future disputes will be settled based upon it. Precedent is one of the core principles underpinning case law. It is based upon the hierarchy of the courts, which gives hierarchy in authority to judgments delivered by those courts. The decisions made in superior or the higher courts form precedents, and inferior or the lower courts must follow these precedents. This is the doctrine of precedent or stare decisis. The question is, what is the importance of case law? What makes case law so important? The reasons are very specific. First, these are the published cases provide a flesh to general constitutional and statutory provisions, providing the meaning of terms within them and demonstrating their application to specific fact situation. Second, via the principle of stare decisis, there is no need to constantly and repeatedly litigate the same issue over and over again, and doing so is prohibited. And finally, third one, the cases provide unique glimpses into history. Case law decisional authority is just as important as constitutional and other statutory provisions. Publishing cases and making them known to the citizens is essential for us to know what is occurring inside the courts. Depriving the people of this knowledge would only foster and promote tyranny.